across a parking lot to get to her house, and this was the only reasonable means for her to do so.
Sorry, counsel, can you point me to where you are in the fact?
That was paragraph 31, moving on to paragraph 32.
But couldn't her husband just have pushed her?
As my co-counsel has submitted, if she would still be in care and control of the motor vehicle based on Lloyd, and thus even pushing her sitting in the wheelchair would still constitute offense.
But surely there's no constitutional right to get drunk. I mean, she could have had less to drink.
The respondent does not submit that there's a constitutional right to get drunk, but she should not be prevented from engaging in typical social activities, which the law does prevent her from doing. The second argument that Chief Justice McLaughlin highlights is that the remedy is available based on the wording of Section 24(1) of the Charter, and this section states that where there has been a breach, a court of competent jurisdiction can impose a remedy as the court considers appropriate and just in the circumstances.
Now, counsel, I do have to point out, you cited to us from Ferguson about the powerful arguments in favor of constitutional exemptions, but of course in the very next paragraph, Justice McLaughlin just says, well, on the whole, these are outweighed by the counter considerations.
I'm just about to start addressing those. So Ferguson does state that the jurisprudence, the intrusion on the role of Parliament, the remedial scheme of the Charter, and the rule of law all outweigh the previous two factors, but the respondent submits that these can be distinguished in this case. So firstly, the jurisprudence. The statement by Chief Justice McLaughlin that constitutional exemptions are not available seems strong, yet she said in the same case that the issue has not been conclusively decided. Furthermore, a unanimous decision of the court in 2010, delivered by Justice LaBelle, which deals with constitutional remedies, omits a discussion of Ferguson. The court in Nazagalawak had the opportunity to affirm Ferguson and conclusively decide that constitutional exemptions are not available as a charter remedy, but they did not do so. Kent Roach identifies this tension and notes that it is odd that it was not addressed. This is particularly curious considering the close decision dates. By omitting this discussion, the Supreme Court is retreating from the hardline approach that they took in Ferguson.
Well, now, we're not bound by the Supreme Court in anything.
No, the respondent submits that that is the leading case law on the issue.
So we can take it that the Supreme Court hasn't decided and it's still open.
As the jurisprudence does not decidedly eliminate the possibility, the respondent submits that the trial judge was correct in granting a constitutional exemption. As for the intrusion on the role of Parliament, a well-known feature of Canadian government is the interplay between Parliament and the courts. In this case, the court is not changing the intention of Parliament or taking away from what they were trying to do. They are simply preventing a law from being struck down when it is possible to maintain the integrity of that law without it having to be redrafted.
Counsel, I want to go back for a second to this tension between Ferguson and you pronounce it better than I do, Nazagala. Couldn't you say that, because you're relying on Kent Roach's argument here that because the court ignored it, that they're basically moving away from it. Usually, the Supreme Court's pretty good. The Supreme Court of Canada is pretty good, and they, especially when decisions are close together, they don't ignore things for no reason. Couldn't you say that the distinction is that in Ferguson we're dealing with a mandatory minimum, and they're answering that question, whereas in Nasagalak what they're dealing with is inappropriate behavior by the authorities, and whether that inappropriate behavior should have an impact on sentencing? Like, don't you see a distinction there?
There is a distinction, but the court in Nazagalawak does address Ferguson in other areas, but specifically omits the discussion when dealing with constitutional exemptions.
But they never address the issue of mandatory minimums, right? Because they don't have to. They're not. It's not put before them. Where Ferguson squarely deals with the issue of mandatory minimums, and says that even though we feel for the officer who but the mandatory minimum is there for a reason, and Parliament's intention is clear. And the court should not tread lightly upon those mandatory minimums. Does that not speak to the tension between the two? I'm having trouble not just saying that the court ignored Ferguson and Nazagala because they were like, well, we made a mistake a couple years ago, and so we're just going to ignore it. And that doesn't sound, especially when it's the same panel, pretty much, the Supreme Court. Can you reconcile those at all? Is it? Perhaps not. Anyway, it's all right. Maybe it's a question to leave in the air. So why don't you paint your argument in terms of wherever you were, intrusion of Parliament, I think.
The respondent submits that it would be a bigger intrusion on Parliament to declare the law of no force and effect under Section 52(1) of the Constitution Act of 1982 than it would be to grant a constitutional exemption to users of motorized wheelchairs. Chief Justice McLaughlin also stated in Ferguson that the remedial scheme of the Charter prevented a constitutional exemption. Given Justice Leloup-Dubé's...
Counsel, that argument, and are we at paragraph 40?
Just moved on to 41.
Okay, well, let's go back to 40 then, because I have trouble with this, because you say it hasn't changed the intention of Parliament, and your only assertion is the intention of Parliament is that passage from Hansard that says driving motorized vehicles while drunk is a terrible thing. And I just really not clear to me how granting a constitutional exemption for wheelchairs, which we acknowledge are motorized vehicles, which we all agree are motorized vehicles, how that doesn't vary that intention.
The respondent submits that the users of motorized wheelchairs, in this case, in Mrs. Smith's case, is reliant on the wheelchair. It has no other means of mobility.
But that might be an argument for sending it back to Parliament, to saying, well, you were concerned about the danger of drunken driving of motorized vehicles. This is drunken driving of a motorized vehicle. You're concerned about that danger, but did you think about how it's going to affect people in wheelchairs? And that's a difficult tension, not an easy one. And isn't the argument, therefore, we should strike down the law and send it back to Parliament to try and get it right, rather than recraft the law ourselves?
The respondent submits that the notice of appeal filed after trial, because of the notice of appeal filed after trial, that a argument based on Section 52(1) to declare the law of no force and effect would be outside of the grounds of appeal, and the respondent would submit that we should continue along with the remedial scheme of the Charter. So the remedial scheme of the Charter, as Justice Leloup-Dubé said in Rose, does not prevent the court from...
So I'm sorry, so your submission is, could you repeat that? Could you repeat your submission on your response to my question? Just please repeat yourself. You referred to the notice of appeal?
In the notice of appeal, it was filed that the constitutional exemption is granted to all users of motorized wheelchairs, and whether or not that is available. And that to argue based on Section 52(1) would be outside of that.
I mean, am I reading the notice of appeal? The learned trial judge erred in finding that the appropriate remedy is to grant constitutional exemption. That's the ground of appeal. And your submission is that she was correct to do so. Is that right?
Yes.
And my point is that this is not an appropriate remedy because it does not maintain the integrity of the law. I'm just not sure how your point regarding 52, Section 52 is responsive. Anyway, proceed.
If I can clarify what he's, I think if I can paraphrase, basically, if we look at that and we agree that the judge erred, right? We agree with the appellant there was an error. Well, we have to have a remedy, right? Well, it seems that there's a couple remedies available to us, one of which is to strike down the law. Would you not agree with that?
The respondent submits that there is no error in this case.
Right. Just listen to what I think what he's asking is, if we agree there was an error, right? So just accept, we're not saying there was an error, but if there was an error, wouldn't our first remedy be to strike down the law? So isn't it within the grounds of appeal? Isn't it something we have to consider as a bench? Isn't that the first remedy, and then we will go to constitutional exemptions, and then we consider standalone exemptions? Aren't these all remedies that we have to consider if there was an error by the trial judge?
Yes.
So we could strike down the law. Is it?
Yes.
And so what are your comments on that in terms of us striking it down and sending it back to Parliament?
The respondent believes that because of the importance of the law, that to strike it down would not be furthering that point.
Okay.
So based on this, the respondent submits that the trial judge was correct in determining that a constitutional exemption was the correct remedy, and while the court in Ferguson raised concerns the issue has not been decided. The second argument in favor of keeping the order of the trial judge is founded on the appellate standard of review. The respondent submits that based on section 687 of the Criminal Code and the recent case law, that the trial judge was correct and entitled to grant users of motorized wheelchairs a constitutional exemption. So the standard of review for sentencing was affirmed in RNCAM, where Chief Justice Lemaire stated that a court of appeal should only interfere to minimize the disparity of sentences.
I'm sorry, counsel, is a constitutional exemption, that's our issue here, isn't it? It's not the sentence. Isn't it a standard of correctness as to whether a trial judge was right that as a matter of constitutional requirement we have to grant an exemption?
Yes.
So I'm not sure how section 687 is relevant to that. We're not varying the sentence, we're deciding whether or not this law is constitutional.
I see your point. Therefore, based on the fact that the Supreme Court has left open the possibility of constitutional exemptions in Nazagalawak, the ruling of the trial judge should not be disturbed, as she was correct in doing so. And based on this, the respondent submits that the trial judge's order should not be disturbed and that the appeal be dismissed on both issues.
Do you have any questions? I have one, and this maybe to you or your counsel. I didn't get a chance for your co-counsel. Here's where I'm struggling. Right? I'll break it down in maybe more layman's terms. What you're saying is that if we allow, or if she is subject to 120 days in jail, then we are punishing her for normal social activity. Because she's in a wheelchair, and that means she basically can't drink. But it's not a zero tolerance policy. She just can't drink to the point of impairment. She could drink. She just can't drink to impairment, right? So there is a window where we're allowing her to engage in social activities. We're just saying you can't get impaired. You can get impaired at your own home. You can get impaired at somebody else's home. You just can't go out in public, become impaired, and drive on the streets in your motorized wheelchair. This is a fact of your life right now. Just as if I lived in the country and I wanted to go into town and have a few drinks, I could not drink to the point where I could not drive home. Right? It is a fact of my life. This is, it's not her decision. I recognize that. So it's not a zero tolerance policy. We're not saying she can't drink at all. We're just saying she has to be conscious of how much she drinks and make plans ahead of time. Is that not a reasonable expectation on Mrs. Smith? Doesn't that, that's not, I'm not limiting her social activities at that point. I'm not punishing her unduly. I'm saying, look, you need to accept the facts of your reality.
The respondent submits that at any point after having any amount of alcohol, she would be in care and control.
But there's a limit, right? Over 80 milligrams per 100, right? There's a limit, right? Impairment is not a zero tolerance policy. I could have a beer and drive, and if the police stop me, I'm not in care control is not an issue, impairment's not an issue. Same with her. I don't know how much she weighs, but I'm assuming she could have a glass of wine or whatever she wants to drink without it becoming against the law. It's only when she drinks past that limit that she's in trouble, right?
The respondent, would I have a moment?
Sure, go ahead.
The respondent submits that as the trial judge was, we should be guided by the principles of equality and non-discrimination, and that subjecting Mrs. Smith to this to 253 of the Criminal Code while she's relying on her wheelchair as her exclusive means of mobility is in violation.
But, sorry, isn't your argument not that she shouldn't be subject to 253, but that the mandatory minimum shouldn't apply? So if she was to do this another 10 times in the next year, well, there should be penal consequence. It can't be that 253 doesn't apply to her at all. The exemption is that the mandatory minimum doesn't apply to her, if I follow the... Isn't that right?
I believe that the
exemption... Is that what the trial judge ruled? It's not an exemption from 253 in general, is it?
It is an exemption from section 253 of the Criminal Code.
Sorry, I'm going to find one. Why don't you quote it then for me?
that the learned trial judge erred in finding that the appropriate remedy is to grant a constitutional exemption from section 253 of the criminal code.
So section 253 of the criminal code does not apply to users more, and so your argument is, okay, so your argument is then that people motorized wheelchairs, regardless of how much they drink, should be able to, like Mr. Shanahan, if Mr. Smith was found driving down Regent Street, weaving in and out of traffic, she should not be subject to any penal consequence, or at most mischief. That's what your argument is.
That's correct.
And you're standing on that? You're okay with that argument? Do you have any questions arising from my question? Did you want to conclude, or have you? I know we're at 0, so.
The respondent would just submit that the appeal be dismissed on both issues.
Okay. Thank you. Now, the appellant has a right of reply. Is there any issue in particular you'd like to?
No, thank you.
Okay, thank you very much. Well, I guess we're going to reserve our decision for 5 minutes, I guess. We'll step out and then we'll come back in and let you know what we decide.